Hi friends, I introduce myself as K. Santhanam, a senior advocate of 47 years of standing and also an academician with 29 years of standing. In my in my profession, I have in my profession, I have handled many civil, criminal, and service matters. I am now. I intend to start a new set of videos which will help the upcoming and new advocates who are entering the legal profession. The emphasis on today's video is the art of cross-examination in civil and criminal matters. Of course, this is only a beginning, and this is only my experience in the profession, and this is not to belittle anyone or anyone's knowledge in civil and criminal matters. Now coming to the topic, today's video is about art of cross-examination. The branches of law have been divided to two parts. One is civil and criminal. First of all, I would like to deal with the civil matters. The civil matters, the rules of procedure which is followed is the Civil Procedure Code of 1908, which has undergone three amendments, one in 1976, 1999, and the present amendment enforced in the civil codes is of 2002. Now coming to the civil side, the rules of evidence is governed by an act called the Indian Evidence Act. The Indian Evidence Act is common to both civil and criminal matters. In civil matters, normally the cross-examination is based on the pleadings, that is the plaint and the written statement filed by either parties, then the documents, and also the various other paramateria which is placed before the court. Normally, it is often said, and the question which always arises is whether cross-examination is an art or a science. But according to me and my humble view, it is both an art as well as a science. It is an art because no one can master cross-examination unless and until he has a thorough mastery over the rules of procedure and the Indian Evidence Act. It is a science because everyone cannot be a successful cross-examiner unless he undergoes a thorough study of the paramateria which is available with him. Here, especially we are in the state of Telangana, where we follow the Madras procedure still. Here in cross-examination, you have a ready material available with you, that is the pleadings, the documents, and oral testimony. And the oral testimony is tested by cross-examination. According to Abraham Lincoln, he says an advocate is one. Describing the qualities of an advocate, he says that an advocate is one, he is fond of air splitting and pedantry. That means an advocate tries to destroy the case of the adversary by his adroit and skillful cross-examination, point by point, fact by fact, and document by document. The mastery in cross-examination is achieved mostly by experience and not by any theoretical knowledge. Any amount of reading books or having theoretical knowledge will not take you anywhere. That is the reason why when we prepare the cross-examination, you must know not only your case, but the case of the adversary. In the Evidence Act, it is said the aim of chief examination is to postulate a case and put forth your case. And the aim of cross-examination is to destroy the case of the adversary point by point and fact by fact and document by document. And one important thing you must remember is admissions play a very important part in the law of evidence. Here in civil matters, we have to get as many admissions as possible from the opposite side. And when we start preparing for cross-examination, it is safer to prepare the questionnaire before you cross-examine the witness. And when you cross-examine the witness, when he is in the witness box, you have to act like a psychologist. That is, you must study the demeanor of the witness, whether he is a timid witness, a false witness, a truthful witness, or a witness who knows only 50% and does not know the other 50%, or is a witness who tries to test the knowledge of the person cross-examining. We have to guard ourselves against untruthful witnesses and witnesses who falter somewhere or the other. That is why it is said, often said, that every thief leaves a clue somewhere, and the job of an advocate in cross-examination is to catch the thief where you get a clue. And when you get a positive answer, don't go to that question again, because you will be giving an opportunity to the other side to correct himself and the witness to correct himself. This has to be avoided at all costs. Now coming to the uh, cross-examination in criminal matters, we are guided by four documents. One is the FIR, that is the first information report. The second one is the complaint. Third one is the 161 and 164 statements recorded by the police and magistrate, and the incriminating documents which are filed by the prosecution. A thorough cross-examiner on the criminal side should always know that presence of mind is very important. When the witness comes into the witness box, he tries to add much more than what he has already stated, or tries to act smart in order to give color to his case. And you have to guard ourselves against those circumstances. So in criminal matters, normally we follow the theory called Lakshmana Rekha. You should not cross the line where you try to prove what the prosecution has not proved, and you try to destroy the case, destroy your own case. Then coming to the criminal matters, inconsistencies, contradictions, and differences between the statements given before the police and given before the court and the documents which support the case of the prosecution play a very important part. And a clever cross-examiner on the criminal side has to keep up his presence of mind, and also try to point out the inconsistencies and contradictions, because in criminal law there are two theories of punishment. One is called the benefit of doubt theory, and another is called reasonable and probable doubt theory. A clever cross-examiner on the criminal side should create a doubt in the mind of the court that what the witness is speaking is untruth and it cannot be believed and it's not trustworthy. Then coming to the other matters like the rent control matters, or the Transfer of Property Act, or the Specific Relief Act, or the other enactments, we have to be guided mostly by the documents as well as the pleadings which are filed before the court. And this, you have to just try to find out what your case is and what is the case of the other side, and then prepare your cross-examination accordingly. Just don't trust your memory, trust the documents. Prepare the case beforehand, and a clever cross-examiner is one who destroys the case of the adversary, be it civil or criminal, point by point, fact by fact, and sentence by sentence, and contradictions and inconsistencies have to be brought out under any circumstances. This is only a short lecture or video, you may call it, which tries to help you in sharpening your brains and also try to be an effective advocate on the trial side. And if these points are remembered, I'm sure that you will be a successful cross-examiner and also an advocate on the civil or criminal side with great success.